evening, all. Distinguished speaker for the day, my dear friends, colleagues, and viewers. It's an honor and privilege for me to welcome you all this Thursday evening. Today's webinar is on the subject matter matrimonial law, two sides of a coin. We are extremely fortunate that today, amongst us, we have an eminent personality and legal luminary who is an authority on the subject matter, not only in terms of the legal knowledge, what she possesses, but also the cases handled, but also for knowing the human and emotional issues involved in it. I take this opportunity in welcoming Advocate Mrunalini Deshmukh ji. Before we proceed to formally introduce Mrs. Deshmukh, let me take this opportunity to communicate on the following. Marriages are deeply rooted in the rich Indian culture as well as the history that we all have been told by our ancestors at some point or others in our life. The Sat Feras, also known as Shatpati, is one of the traditional ceremonies during a wedding which is performed along with the chants of a Pandit based on the Hindu scriptures, where the bride and grooms have to take 7 rounds around the fire. It is believed that the god Agni resides in the holy fire that solidified the union and bond of the bride and groom who took 7 vows in his presence. Those 7 vows are: the first vow is the prayer of the Lord for provision and nourishment. The second vow is for strength in sickness, health, good times or bad. The third vow is for prosperity. The fourth vow is for families to stand by them through thick and thin. The fifth vow is for progeny. The sixth vow is for health through sickness and in health. The seventh vow is for love and friendship. At this junction, it would not be out of place to mention that life is not all about mills and booms or a Yash Chopra movies. And sometimes it does derail, and at that moment, hard facts are encountered, both in terms of challenges in legal system as well as the maturity to deal with such situations. Now, without taking much time, let me formally introduce to you all our esteemed speaker. Mrunalini Deshmukh Tope has graduated in economics and has done her master's in law. Mrs. Deshmukh is a renowned lawyer practicing over a decade and a half with special expertise in family law. Mrs. Deshmukh is an alumni of prestigious St. Xavier's College, Mumbai and the Government Law College, Mumbai. She holds an LLM degree from the University of Mumbai in commercial law and matrimonial law. In the past, Mrs. Deshmukh has been a professor of constitutional law at the KC College, Mumbai, and taught the postgraduate students as a visiting faculty at the Department of Law, Mumbai University. She belongs to a family of jurists wherein her father, late Dr. T.K. Tope, was a constitutional expert and professor of constitutional law, who later rose to become the vice chancellor of the Mumbai University. She has been invited to judge various prestigious moot court programs owing to her expertise in her field of practice. She has also addressed and contributed in writing towards the issue of sexual harassment at workplace and also regarding issues of safety of women and children. She has been invited an expert by several MNCs on committees to deal with sexual harassment cases at workplace. Mrs. Deshmukh often participates and addresses domestic and international conferences on issues relating to family law and structuring of wealth and alimony issues, specifically the laws governing women. Mrs. Deshmukh strongly believes in gender justice and is extremely sensitive about injustice and malpractices while active propagating gender equality. She recently addressed an international conference on wealth planning for global Indian families in Dubai, UAE. She has authored book on diverse issues on matrimonial laws published by Penguin Publication. She has to her credit several conferences and events where she has addressed national and international audience on various subjects of her expertise. She addressed the Columbian University students at South Asia Millennium Conference on Sexual and Domestic Violence in South Asia and addressed the international lawyers and juries from countries like USA, UK, and Australia, and other South Asian countries on the ethics and value of legal practice. She had been on the board of various companies, including Talwakar Better Value Fitness Limited, Ford Facility Services Private Limited, and currently is an independent director in Kirloskar India Limited and Kirloskar Oil Engine Limited. With that, I once again welcome Mrs. Deshmukh and thank her for accepting our invitation, that is of Udan Saluters, and agreed to share her knowledge and wisdom for the benefit of the society at large. I request all the participants to kindly punch their questions and queries once the question and answer session is commenced. And all those who are watching live in various social media platforms like Facebook, Instagram, YouTube, to send their queries in comment section. Madam, now the session is all yours.
Good evening, Rishikesh. Good evening to all of you here. And at the outset, I thank you for such warm words and such flowing sort of words about me and what my little bit of work that I have done. It's indeed a pleasure to be here this evening and to address on what are known as what are the matrimonial laws, what are the various issues which are there, and how does everything flow out. You have given a very sort of succinct introduction to us and all of us as to what marriage means under the law and under the Hindu tradition or any other traditional law, and what is the repercussions of in the events the marriages do not sort of, they do not grow well, they do not succeed, and they sort of lead into a divorce. Now, before I get into this part of it, there was a philosopher by the name of Osho, many of you may have heard about it. And just to start on a little lighter note, he had said that why does one get married? He says one gets married because of lack of judgment. Then the same breath, he says, why do people get divorced? He says, because for lack of patience. And why do people after divorce again get remarried? And for that, the answer is lack of memory. I think it sums it all as to what the issues currently we are facing, what are the issues that the society as a whole is now undergoing. In fact, the other day I was having a discussion with somebody from the judiciary, and I was informed that currently, and this is for the last 4 to 5 years, past 4 to 5 years, the maximum number of cases that the courts are dealing with are the matrimonial cases. And I'm talking about the different fora. It could be at the lower court level, it could be at the district court level, it could be at the high court level, Supreme Court, etc. But a sizable portion of the cases that are being dealt by the judiciary are dealing with the various aspects of the matrimonial laws, be it divorce, be it custody, that's child custody, be it alimony part of it, maintenance part of it, domestic violence, and so on and so forth. So why is it that today we see such a surge or such a rise in the number of matrimonial cases that are hitting the courts? And what are the social factors and what are the legal provisions which are there in law for us to understand? Now, to understand this, basically, we first need to see the evolution of the law. And I won't take more than 60 seconds. The law was codified on marriages and divorce only after the independence and after the Constitution was framed. So we have the Hindu Marriage Act, which I'm going to just take as a base marriage act for the purposes of understanding. So we have the Hindu Marriage Act in the year 1955, which is where two Hindus can get married as per the rites, which Rishikesh just told us, the Pera, that is the column of essential ceremony. Then you have a Special Marriage Act, where two people from two different religions, like if you are a Hindu and you are a Muslim, and you do not want to convert into either of these religion which is there, you can get married. So which is known as a secular law without giving up your religion. Then of course you have the personal law of the Muslim, which is the Muslim marriage law, Parsis, Christians, and so on and so forth. So you will now realize that all our marriage laws are personal laws, and our personal laws are based on our religion. So this is, I would say, a very unique feature of the Indian marriage laws and the divorces and custody and so on and so forth. At the same time, we have to understand that the law framed in 1954, 1955, or some of the laws like the Parsi Marriage and Divorce Act and the Indian Christian Marriage Act, which was pre-independence act, have really evolved over a period of time. And I would say typically in the last 15 years or 20 years or so. And this has been evolved not only by the various amendments that have been carried out to the legislation, but also by the judicial activism and the judicial pronouncement of judgments, keeping in view the social scenario and the social sector which is there. So I think the evolution of this law has been both a combination of what the social factors were, which reflected in the law, and what were the legal issues which reflected in the society. Now, after having gone through and understanding that our laws are based on the religion that we are there, what are, in the event the marriages go south, in the event the marriages do not work, what are the remedies available under the matrimonial law? Now, when we are talking about what are the remedies available, we are talking about not only divorce. Divorce is one part of it, but there are other ancillary or related issues also which follow once a person decides to go for a divorce or a decree of divorce is granted. So before we go to divorce or the dissolution of marriage, let us understand that in the legal provision or the laws that are there, there is a provision for divorce, that means to dissolve the marriage. There is a provision of judicial separation, which means you do not dissolve the marriage, but you are allowed, permitted in law to live separately without giving up your title of husband and wife and your relationship in the eyes of court. So that's judicial separation. And you also have something what is known as restitution of conjugal rights, which is also a part of the matrimonial law. Now, what is very interesting about the restitution of conjugal rights is that in the event, let me take an example, in the event a wife has left the husband and she is gone and she's staying with her parents or she's staying independent, the law provides an option for the husband to go to a court of law and make a case to the court and say that I'm legally married to this lady, she is my wife. She has left me without any reasonable cause or without any justifiable sort of grounds. And you, the Honorable Court, please direct her to come and resume cohabitation with me and come and live with me and reinstate my conjugal rights as we are legally married. Now, this is something which is a very unique provision of the Indian law, where restitution of conjugal rights is there. And one of the reasons for this particular law is only because these laws are based on the concept of the Indian way of looking at marriages. Whether it's a Christian, where they say till death do us apart, whether it's a Hindu thing, which is till the end is there. So the permanency or the permanent nature of the marriage has to be restored, and that is why the restitution of conjugal rights is there. Now, these are very, very legal, big legal jargons which are there, and we don't need to get into it because this is not a law lecture for law students or for lawyers. This is basically for all of us to understand that what is the social scenario as far as this is concerned. Now, when we talk about a divorce, and let's take that because that's the one thing that people are now hearing. Now, if you see, you open any newspaper or you see any of these social media things, then you will see that the media is reporting a lot of cases which are basically arising out of a matrimonial dispute. Now, those may be related to the socially known and the celebrities because it is increasing their TRP, or it could also be leading to people like you and me who are normal people, but the issues are very different, and that's the reason they want to deal with it. Now, when we talk of divorce, there are two ways of getting a divorce. One, what is known as the fault theory. I'll come to that. And secondly is what is a divorce by mutual consent. Now, what is the fault theory of divorce? The fault theory of divorce involves that one of the parties in the marriage has committed a matrimonial wrong, and as a result of which the aggrieved spouse will have a recourse in a court of law to take relief in terms of divorce. So what are those grounds on which a person can take a recourse for divorce in a fault theory? One, which is popularly known, is cruelty. Now, cruelty as normally understood is not only physical cruelty. It also means mental cruelty, emotional cruelty. It also means causing grief and pain and anguish to a person in the period, during the period of their marriage, which entitles the aggrieved party to go to the court. That is cruelty as understood in law. I will also come a little later to how are the analogous criminal provisions with regards to this, which are also offenses of marriage, and which I'll come to. The second ground is desertion. Now, what is desertion? Desertion means a spouse has left the matrimonial home for a period of 2 years. Me as a husband, I have made effort to bring her back, the wife who's left the house, but she's not coming back for the next 2 years. And then I go to the court and I say that I'm a husband here. My wife has left me without any reasonable cause. And now I don't think I want to live with her. The first example which I gave you of restitution of conjugal rights was where the husband wanted the wife to come back. Now, this example I'm giving you of desertion, that for a period of 2 years, I made effort to bring her back, but she is not coming back. So kindly grant me divorce on the ground that she has deserted me, abandoned her matrimonial duties, and she has left me in lurch, and I'm entitled for divorce. So desertion is the second part of it. The third important ground is adultery. Now, those of you who are lawyers or who are active enough to read all the things that happen in the courts, adultery is a ground for divorce because adultery means either one of the spouses has committed a matrimonial wrong of having a sexual relationship with the other person who is not her husband or who is not the wife in the marriage. So a married person having sexual relationship outside the marriage without a divorce or without any of these things is an act of adultery. So that's the third ground. The fourth ground is about the mental health and the unsoundness of mind. There could be cases where there are people who are having some mental health issues, who would be having things like they're bipolar, they're schizophrenic, there are and several other things which are there. And under such circumstances, their behavior, their conduct is causing grief to me as an aggrieved person. I can go to the court with all the medical reports, etc., and show and get them and justify my reason for the divorce. Then there are certain other grounds which are there for women, which are more of nature, where there is an assault on her sexually and so on and so forth. Now, these are the false theories of divorce. Now, in a false theory of divorce, the burden is on the person who is claiming that. If I am claiming that my husband has deserted me, then the court says it is on you as a person, as a petitioner, as we call it, or a plaintiff, who has to prove that that the husband has deserted without a reasonable cause. So the false theory, in my experience as a lawyer, becomes an extremely difficult thing in a reality and in practical sort of scenario to be able to be explained to the court to understand what my pain and anguish or what the issues are. The false theory of divorce was also later understood that there need not be two people who are either somebody has deserted or somebody is cruel or somebody is of unsound mind. But there could be a situation where two people who are good individual souls in their own way did get married. But somewhere down the line, they found that they were incompatible, or they found that there were irreconcilable differences between them. And as a result of which they want to part. Now, does it mean that I want to go and say, no, he's bad, he did this, he did that, and so you want to do? So there was no such provision in the law in the 1955 or the 1954 Act of the marriage, which was the Special Marriage Act and the Hindu Marriage Act. So the amendment was brought about in the year 1976, wherein for the first time, the legislation introduced in the enactment a provision for a divorce by mutual consent, and they laid down the things which are there, that the parties have to be married. But it doesn't mean divorce by mutual consent that you get today. You have a fight after 1 month and you go to the court and say, okay, now we are not getting along, you give us a... No, they have laid down certain terms and conditions. Number one is that you cannot file for a divorce by mutual consent unless there is 1 year from the date of the marriage. Number one. Number two condition is you cannot apply for a divorce by, this is not or. So 1 and 2. Number 2 is that you cannot get divorced unless you have not been separated for a period of 1 year. Okay. Number 3, that after you file for a divorce by mutual consent, which would be on the ground of incompatibility, irreconcilable differences, the courts give you a minimum period of 6 months as a waiting period, which is a statutory mandatory waiting period, where the courts give the parties a chance to rethink, to reconsider whether they really want to get into this divorce or not, or have they come to the courts in a hurry, in a rush, out of impulse and very impulsive and reactionary action? So 6 months are given for the couple, to decide to whether they want to go ahead for divorce. After a period of 6 months, the courts then once again reaffirms from them, you husband, are you agreeable? You wife, are you agreeable? Are you sure there's no force, there's no coercion, there's no undue influence on either of you? Is there any fear factor? And so on and so forth. And only the section says that only when the court is satisfied. So even in a divorce by mutual consent, the court has to be satisfied that the divorce is something which is voluntary and both want to lead their life and want to get out of a marriage which is meaningless for them. So this brought about a lot of grace, a lot of dignity in a way it was there. And one didn't have to fight in courts, which is there. The thirdly, and more importantly, is that after this divorce is there, what happens after the divorce? So there are various issues that are there. Divorce is what? Dissolution of marriage. Husband and wife are legally separated. But there could be various issues which are there. Issues are, number one, is what about the children from the marriage? So if there are children from the marriage, and basically minor children, minor, as we all know, is below the age of 18. What is the position as far as their custody and care is concerned? What is the position as far as their child support, education, health, etc. is concerned? And what about the time that each parent can spend with the child is concerned? So the issue of custody, which is one of the ancillary reliefs of divorce, is an extremely crucial issue that the courts have to deal with. And this is an issue where the courts have to deal with utmost sensitivity and with utmost, with kid gloves, as one would call it, literally. We see that in our profession, in our experience, we have seen that the issues of custody can get ugly, can get where the child is being pulled and pushed like a tug of war between two people. Or on the other hand, there could be, and I have dealt with quite a few cases, where people could be extremely mature, they could be extremely practical, they could be extremely, look after the interests of the child and not fight over the custody of the children, but amicably decide between the two of them, that is the husband and the wife, and that is the father and the mother, that how you should share maybe the money part of it, the time part of it, the decision-making part of it, and the future of the child. So such parents who show extreme maturity and understanding and keep in mind that their personal squabbles should not have any effect on the child. The child should not grow up with any emotional baggage of his childhood, because when he becomes an adult and when he starts his life, he should not have any of those things. They look at these things in a very tender manner, in a very matured manner, in a very dignified manner. Now, these days, as far as since we are on the custody, I would like to share a very interesting thing. Is these days we are having a lot of these cross-border custody issues. I'll give you an example. What is a cross-border? Couple gets married in India. Okay, citizenship, they are Indian citizens. They get married in India because their parents are here there and they're working overseas. They get married and they go to, I'm taking UK for example, and they go and they reside in UK. Over a period of time, they acquire citizenship or they don't acquire citizenship. And there's a child born. The child is born, the child is a citizen of that country by birth. Issues arise, disputes arise, then what happens? Now we have a lot of these such cases which are there. Because before we get into it, we must understand that in countries like USA and UK, it is a very clear direction and a clear law that a child who is caught in the matrimonial dispute or the divorce issue, the child is always under the joint legal custody and the joint legal guardianship and joint parenting of the child. So there is no such issue one or two. So this is how the courts look at it, because the child belongs to both the parents, and that is why they have to be treated in that manner. So the case that I was talking about, then the couple goes to London, to UK, and then they have a child. They have some issues which are there. Now I'm talking and I'm sharing my case that I'm dealing with. In this case, the wife was having a lot of insecurity. She had a girl child. She knew that if she stayed in London, they were both professionals, very successful professionals in UK. that if she continued to stay in London or in parts of UK, then the custody issue would be decided by the courts in this manner. And for whatever reasons, that is, without attributing any reasons to her, she took the child from UK and flew down to Bombay, to India. She comes down to Bombay, India, and she files a case in the India-Bombay Family Court and says that I want this court because I have an OCI card, so I'm a British citizen. My child is a British citizen, but the child is, I think it was 3 years or 4 years of age at that point of time. And I have a fear that my husband will remove the child from my care and custody. So I want to assume the jurisdiction of this court for the purposes of custody. This is cut one. Cut two, in UK, the child is abducted, so which is known as parental abduction. So not kidnapping, but similar to that. So a child is abducted from UK and the child is brought here. The courts in UK do consider the children to be the ward of the, so they are the guardians and the child is the ward of the court, which means the courts are the parents and the child is under their care. So they look at it in a very strong manner and they pass orders that the courts, that the child, not the courts pass an order that the mother who has taken away the child who is also a UK citizen but not in UK at the moment, that she's directed to bring the child back here to UK, and the UK courts will decide the issue of custody. Not necessarily that they'll give it to the father, but the issue of custody will be decided by the UK courts. Now the husband comes here armed with this order that I wanted. Now see, I've got an order and they have been asked to come back. So in this case, what happens is the wife has already obtained an order from the Bombay Family Court as a how do I say, emergency remedy that the child cannot be removed from her care and custody. The husband brings it here. The courts in India, and this is the most important point that I'm trying to say, the courts in India have consistently taken only one parameter as the absolute parameter to decide the custody of the child, is the interest and the welfare and the best interest of the child. So what is in the best interest of the child, what is for the welfare of the child, are the yardsticks on which the courts decide how the custody issue is to be there. So it is not the right of the parent, parent A or parent B, but it is the best interest and welfare of the child. And what is best interest and welfare of the child? There are certain parameters, which is the age of the child, the support system that the parent has, the kind of environment that the parent has to give a supportive, a healthy, a nutritive, and a very nutritious, how do I say, blossoming of the child, and so on and so forth. So these are the things that the courts take into consideration. But these cross-border issues currently are becoming the order of the day, if I may call so, because there are a whole lot of professionals who come here, get married, settle abroad, and these are the issues that are taking. Now, so one of the things was custody. So as I said, custody is decided by the court on the parameter of best interest and welfare. The second issue which is an ancillary relief that comes up. What happens if a spouse is unable to maintain herself? She does not have sufficient money. Now in India, and let's not go by the urban metros or the other two-tier cities which are there where women are financially independent, educated, etc. But a large section of the women are basically homemakers. They get married and they come home and they start residing with the husband and they do their household duties. God forbid a situation of divorce arrives. What do they do? Where do they go? So there is a provision in law which says that in the event a woman is unable to maintain herself because she doesn't have finances or she has certain responsibilities, the courts direct the husbands to pay maintenance. So at an interim stage, that is in the temporary stage when the matters are pending, you have what is known as an interim maintenance. And when the divorce is granted or decided in favor of the husband in such a case, then the courts decide what is the alimony. So alimony to be given to the wife as a part of, so that she is able to sustain herself and lead a life with dignity and grace and not be sort of, face a situation, a dire situation because she has no money. So it is very clearly the laws of alimony, the laws of maintenance, etc., come under this matrimonial marriage law because it's a part and parcel of the marriage law. Now, how is alimony decided? Now, there are a whole lot of things, and I think we will need a whole sort of one more webinar only on that. How is the alimony decided? But if I may just touch upon the bare facts and not getting into the details of it, because I'm aware of the fact that there are some of the viewers who are not lawyers. So basically, it is decided on the income of the husband, the income of the wife, if any, the standard of living of the parties. What is the kind of standard of living that they have? Sometimes the courts also consider number of years that have been invested in the marriage by the wife. So somebody who is invested in the marriage for 2 years or 3 years, as compared to this another case where a person is invested around 20 years in marriage, the courts are going to have different perspective in granting the alimony which is there. And they see the overall lifestyle and the status of the party and the age of the parties also. The reason for age of the parties is also that people who get divorced at a younger age, in their 30s or 40s, the courts, it is expected now that there's no such rule that says that you can't get remarried at 50 or 60 or 70. I'm not saying that. But what is the bent of mind of the court is if you're in 30s and 40s, there's a high probability that you may get remarried. And if you get remarried, then you have a chance of finding a new life, a second innings. And that is why you may not be required to be provided a higher amount. But this again, as I said, things of alimony, though there are parameters which are laid down, are also the subjective views of the court, which decides considering all these factors which are there. Now, after we've gone to maintenance, alimony, child support, etc., these are all what are known as the civil aspects of it. Now, there are certain offenses in marriage also. Now, when I mean offenses in marriage, I'm talking about the criminal part of it. Now, what are those offenses in marriage? Now, the marriage entails a lot of responsibility, a conduct, a behavior which is there. But if you see the Indian tradition, and this has been typically what has happened in the courts, and that is why the need was felt by the courts to amend even the Indian Penal Code. And the Indian Penal Code was amended only in the 1983, only with a view to make and have a strict action against people who were using social customs and social norms to perpetrate violence on the woman. A typical case is that of a dowry. So a dowry menace was a great menace, and as we all know, and we've been reading over the period of time. And that is the reason where a lot of women, there were certain cases of bride burning, there were certain cases of harassment, there were certain cases of torture, which was perpetrated to the woman because she could not bring sufficient amount of dowry from her parents' house under the garb of social, so the custom and social norms. So this made the legislation decide that there should be something which is more effective. There should be something which should curb this menace, and a law should be a deterrent law. And that is why something like, which we all know, and I think every person knows, Section 498 capital A was introduced in the Indian Penal Code, which talks about cruelty which is perpetrated to the woman, which could be cruelty physical, which could be mental, which could be emotional, which could be because of incessant demands, monetary demands and dowry demands, etc., which are there. All these things, the woman had a recourse to go to a court of law, to the police, make a complaint, and and in the complaint put that I was married, this was given, etc., etc., and this is the way I have been treated by my husband, by my in-laws, or by my people who are around, and kindly take some strict action against them. Very noble amendment, absolutely necessary, because we have to put an end to this menace which is there, and a very laudable effort on the part of the legislation to bring about this amendment. There was also the Dowry Prohibition Act, which was there, where giving and taking dowry was a criminal offense, and the law could treat in this manner the way they felt appropriate. I'll come to the abuse part of it a little later. The third part of it was that there were a lot of women particularly, and I'm not being women-centric, this webinar is not women-centric, but I'm just giving you based on the statistics which is available, that there were a lot of women who were battling domestic violence. So there was a case of physical domestic violence, there was a case of mental domestic violence, financial domestic violence, emotional domestic violence. And such women had no other recourse but to go to the courts of law and ask either for maintenance or to ask for divorce or to ask for any other relief which is there. But the husband was not penalized for the wrong that he committed in terms of the compensation that he needs to be paid. So in the year 2005, the Prevention of the Domestic Violence Act, which is basically for the women, was enacted. And the Domestic Violence Act today forms a major portion of the matrimonial litigation. The advantage of, or I would not say advantage, the thought process of the legislation when they brought about the Domestic Violence Act is that anybody who was in a domestic relationship, and if this is only for the women, if she was subjected to any kind of violence, she had a recourse under the Domestic Violence Act, make a complaint, the police would give her a protection officer, she would go to the magistrate's court, she could ask for interim reliefs like maintenance or protection, that I should not be touched, nobody should hurt me, etc. And lastly, and more importantly, that because of the domestic violence, I should be compensated because it's a civil wrong and the husband has to compensate me for that. The Domestic Violence Act basically gave a lot of comfort and a lot of options for the woman who was trapped in such kind of relationship. The unique feature of this act is that the Domestic Violence Act for the protection of women need not necessarily mean the wife, but could also mean a lady who was in a live-in relationship. So in a way, if I may say so, the court did recognize, though a live-in relationship is not a legal relationship because there's no marriage over there, but the law recognized that in the society there are issues, there are situations where couples have a live-in relationship. So whether a woman who is in a live-in relationship, does she not have a recourse to the safety issues or whatever the other things are there? So they have now introduced the concept of a woman who is not a legally married wife, a legally wedded wife of the husband, but who is in a live-in relationship. That's how they have expanded the court. And they have made the person, of course, if I am the person in a live-in relationship, I have to go to the court and explain that I'm not married to Mr. X, but I've been living with him for the past 5 years or 6 years, and certain evidences which are there, and the violence that he's perpetrated, and I should be taken care of. Now, all these things are the basic laws which I have given. I've just given you a rough sort of, a flow of the sections which are there. What happens typically when a matter goes to a court of law? And that is why in 1984, the act was made. Seeing the number of the rising numbers of divorces, the rising number of matrimonial disputes and other issues which were there, the district courts and the civil courts were unable to handle it because they were doing other matters also. And this required a very, a very systematic way of looking at it, a very sensitive way of looking at it, and a different format of looking at it. So in the year 1984, the Family Courts Act was enacted, in which a special enactment, a special forum, a special court was created only to deal with these matrimonial issues. And these matrimonial issues are now in most of the urban metros and other two-tier cities also being decided by the matrimonial court, in the family court. How does it matter? A person goes and files a case. Let us say it's a contested case. Does the court say, okay, come, you file, I'll give summons to the wife and then I will decide the case? No. Once you go to the court and the case is filed, and on the first day the matter comes up, the wife is also there. Suppose the husband has filed, the wife also comes up. The courts are not going to decide your matter. The courts are first going to send you to the court-attached counselors. So every court has 1 or 2 counselors which are there. So first the parties have referred to the counselor. The counselor will talk to the parties and find out that why are you here? What is the issue? Can we find out? Can we sort it out? Can we just mediate as a counselor and find out what your issues are? So the first job which is done is to see that they resolve their issues, they come together, and they go back satisfied. The other thing is that if the issues are absolutely very irreconcilable, or there are grave issues which are there, then can the family court, can the counselor bring about an amicable settlement between the two parties? Okay, don't fight. You have an issue. Let me sit down. What is it you want to divorce? Are you wife agreeing for it? What do you want to do about it? So this is how they have done. So before it goes to the court, the parties are subjected to counseling 2 times, twice, thrice, depends on the number of issues they have. And only on the counselor giving a failure report that I as a counselor tried to do everything, but they are not reconciling, or I'm not being able to bring about a settlement. Now you, court, you decide the failure report which goes, then the matters are dealt by the court. Even when the matters come to the court, even the judges play a very important role. They are not here to decide that, okay, is this your property, is this his property, and so on. They are here to resolve the issue because these are family issues. The judges also play the role of the mediator. In fact, it is very interesting to know that in the Bombay Family Court, and I'm sure it is there in the other courts also. So we have 7 courts here in the Bombay Family Court. If a matter is, say, for example, pending in courtroom number 2, and the judge, whilst he's dealing with the matter, realizes that, listen, there's somebody somebody who is responsible, somebody who is an effective person, the counselor has tried, does not work, should be able to tell them that what they are doing is not right, and that litigation is not an answer to their issues. The courts appoint the judge, who is, suppose on the second floor the judge is there, the court will appoint one of the sitting judges who is in the court as a mediator. So even suppose a courtroom number 5 is given the role of being a mediator. So he's a judge who is a sitting judge. He's not going to decide the matter on the merits, sorry, but he, with his experience and wisdom, is going to prevail over the parties, the futility of a litigation, and the advantages of an amicable settlement. So we have a procedure of judge mediation also in the family courts. And the third thing is that today with the ADR, that is the alternative dispute redressal, and the mediations which are taking place and which is recommended even from the highest Supreme Court level to the lowest level, there are court-appointed mediators also who have been given the job of talking to the parties to bringing about an amicable settlement. So what I'm trying to tell you here is that at every stage, the effort is being made to try and resolve these issues in a peaceful and amicable manner to the best possibility. If not, then the courts have to decide on the merits of the case. Then, of course, then they have to go by the documents and they have to go. Now, the question that arises is that, is this how everything works? Do all matters go through this? Is there any hope for such people? Are there any cases that I have dealt with which have been a little different? And I'm going to share a very interesting case that I have dealt with. I think some of you who may have heard me in the past may have sort of heard me about it, heard me mention about it. But I think it's very important because it has taught me something, which is how life is and how truth is stranger than fiction. It dealt with it's a case of a well-known person from the Bollywood. He got married. So let's say 15, 20 years back. He got married to this lady. They lived together for a couple of years or so and so. They had some differences. They went to a lawyer. And they told the lawyer that, listen, we are not getting along now. We have nothing against each other. She says, I don't want anything. I do from him. He says, we have no child, nothing. We just want to go. But this was a lawyer who was not being an officer of the court and who misled the party, who should have otherwise told him, let's go to the court. But he said, you're so comfortable and so amicably you want to do it. Let me draw up a document. So he draws up a document which is like a memorandum of understanding. In that, he says that I will give you, and on 100 rupee stamp paper, he says that I so-and-so, I miss so-and-so, we got married, we want to separate, and we have no claims against each other, and then we want to dissolve the marriage, and we hereby declare that we want to divorce each other. He takes that thing, he stamps it, he gives it to a notary. These people think, oh, they are divorced. It's such a simple process. You go to the lawyer's chamber and it is done. Ignorance of law is not an excuse, is all that we know. But still, these people were ignorant. Let me just accept that. Then this lady gets remarried. She has 2 kids. This gentleman gets remarried. He gets a daughter. They live in their respective relationship for, say, next 5 years or 10 years. The husband has a problem in his marriage, and he's being an artist. He was traveling, and he went to New York. The lady who was his ex-wife, she was also married. She got married to a doctor. She had 2 children, and who was also living in New York. But they had no connection with each other. While he was in New York, he was sitting in the bar or in one of the coffee shops. He accidentally met this ex-wife of his. They met, and it was love that again surfaced. They were very happy to meet each other. They met over dinner. They met over coffee the next day. And then they realized that both are unhappy in their respective relationship, that is the second relationship. Then they decide what is to be done. They say that we made a biggest mistake. We should not have got divorced. We had adjustmental issues, but we could have done that. So they came together. Then at that point of time, the gentleman comes to me and he says that I want to divorce my wife. That is, let's call her the second wife for the sake of the argument. That I want to divorce my wife and I want to move on in life. So I said, okay. What happened? He said, earlier I was married, but I was divorced. I said, okay, show me your divorce decree. So accordingly, we can proceed. So he shows me the memorandum of understanding, which is an MOU. I said, no, I'm asking you for a decree of divorce, which the courts granted. He said, no, we didn't go to court. The lawyer was a great rock star. He just told us, I will sign it and you will get the divorce. So we have nothing which is there. I got married. My second marriage is registered. The lady's marriage, who I plan to lead my life with, is also there. So I said, but this is not legal because you are not divorced from your first wife. Then he said, oh, that's great. So that means I don't have to divorce my wife. I can just go and start living with this lady whom I'm in love with. I said, no, that's not what it is. There is still a procedure because today you are married to her. Socially, though legally, that could be considered as a second marriage, which is not right. But socially and even otherwise morally, there are certain things which have to be done. Ultimately, we were able to resolve this legally with the help of the court because we were honest to the court and we told them what the things are. And that's how this thing was resolved. Today, and I'm talking about this 8 years or 10 years back, they came back together, the first couple, and the lady has 2 children from her second marriage. The gentleman has 1 daughter from his second marriage, and now both of them have 2 children from the new reunion. Such is life. Such exciting things do happen in life. So it's not that if you're divorced, it's done. Once a divorce, always a divorce. No. There could be cases which do give you hope that there is much more to life than divorce. The other case which I would also like to share with you is, and Rishikesh, how much time do we have, or do you want to go into question answers?
No, ma'am, you can continue.
Okay.
Please continue.
No, I won't take more than 10 minutes.
Sure.
Take not more than 5 or 10 minutes. I'll give you this case because these are the cases which I've dealt with personally. So I have the knowledge about all the facts. And these are also cases which are learning lessons. And there's a lot to learn from this. So there was this couple which was there. They were married. They had grown-up children who were around 20 or 22. And apparently in this case, the wife got into an adulterous relationship with somebody else. The husband found out. He was a very sharp and smart cookie. He had trackers in his car, in her car, and he had a private eye, and he got everything done. And he caught the wife red-handed, as one would call it, with the other gentleman in one of the hotel suites. It was there. He came to me, and he was teething with anger, and he was absolutely bitter. And he said, I want to destroy my wife, and I want to destroy that man, and I want a divorce, and I want to do, etc., etc. Very, very angry, very, very, how would I say, absolutely in a rage. I just calmed him down, and I told him that, okay, let's see if there is a recourse you have in law, and let us try and sort it out. At that point of time, and this is very important for you to understand, that this was a case of adultery. Earlier, in the Indian Penal Code, until it was until it was amended. And not amended, but by the decision of the Supreme Court, with the Honorable Supreme Court struck down for 97, which is adultery. The law was that in the event a husband and wife were married, and the wife got into a relationship with another man, in an adulterous relationship, the husband, in this case, had a recourse in criminal law against her paramour or her boyfriend, as we may call it. So he could file a criminal case against her, against the man, not against his wife, against the man, saying that you have committed adultery with my wife. So obviously the wife would be a party, but would be the dormant party. And also there was a section under the law which says that enticing away a married woman. So these were the two clauses, or these were the two sections that were applicable. So the husbands could file such cases also, the criminal law. However, now that is no longer a law because the Supreme Court has struck that down, and they have said adultery can only be a matrimonial wrong. So in this case, this was before the Supreme Court judgment. I'm talking about this case around 3 years back, or 3 or 4 years back. So he said, I want to file a case against this gentleman. I want to expose him. He was also a well-known personality, a professional, and I want to expose him. I want to do extra. Just calming him down to tell him that, listen, don't get into all these things. He filed a case. He also filed a case for divorce over here. And these divorce cases don't happen over a period of time. I mean, they take a substantial period of time and they don't happen in a jiffy. So after 6, 7, 8 months of this, whilst we were going, every time we were going to court, we were waiting. Sometimes the court heard us, sometimes they gave us dates, and we were going. Whilst we are waiting one of those court dates, the wife came to me and she said, may I speak to you? Though you are mine. I said, surely. My client and her husband was standing next to me. I asked him, I said, I'm sure you have no problem. He said, no, you can speak to me. She said, is there some way we can end this? I think this is becoming too toxic for all of us, for my children, for my husband, for me, etc. And I want to just find a solution. So I said, sure, let's try and find out some solution. By which time, over a period of time, this husband had also a little calmed down and he was okay. We met with her and her lawyer, and we met for 2 or 3 sessions. Then I requested them that, listen, it's your issue. Don't get lawyers every time. Why don't both of you go for dinner? Just the two of you. Scream, shout, yell, do whatever you want. But talk. You have to talk. Unless you talk, you have to get it off your chest. They went for dinner on 2 or 3 occasions. One of the dinners was with their children. And after that, when they came to me and they said that we have now decided to reconcile. The husband had said, I want my wife back. I want my family back. And I do want to live with her, though she has committed the act of adultery. The wife came and told me, along with her lawyer, that whatever has happened was my mistake. And I shouldn't have done it, but it happened. But I think we now want to look ahead of life, be together, and also take care of the children, because though they were old enough, 21, 22, they are not settled down enough. And today I'm so happy to share, so happy to share that the couple is together and they're very happy. Such strange are the things that happens in the matrimonial court. It's not only anger, it's not only revenge, it's not only, sort of tearing each other apart. It's much more than that. We have seen that these are the civil part and the emotional part of it. The other thing that I just want to share is that today, with the laws where the women have been empowered, we have seen cases where there has also been abuse of the law. Section 498A, which I just discussed, which was a criminal amendment to the Indian Penal Code, which gave a lot of strength and empowered the women to deal with the atrocities of dowry, harassment, etc., were misused by some section of the women only as a part of revenge, either to make extra money or out of complete to destroy the family, and false cases were being filed. This became a pattern at a certain point of time, and the courts, including the Supreme Court, took note of this. And there are 2-3 case laws which are there, which is Animesh Kumar versus Union of India, the Manav Adhikar Samiti versus the Union of India, etc., in which the courts have said that the intent with which this legislation was brought about has to be sort of respected and followed. But any abuse to that effect cannot be tolerated. and set out certain guidelines which are there. Even the Delhi High Court, in one of the judgments where they granted bail to one of these so-called accused in this matrimonial issues, were there, laid down that how at every point of time there is the need of a counseling, there is a need of a mediation, there is a need for someone to calm them down first to take some things which are there. And here I would like to say that it is also the role of a lawyer who is dealing with these matters to play a very mature and not a very negative or a restricted role. The lawyer has to assist the courts to settle the matter. The lawyer has to impress upon the litigants that going to court is the last resort you should opt for. Try and resolve these issues which are there. So friends, there's a whole gamut of this. If I go through custody, if I go to alimony, if I go to the cross-border issues, if I go to the other, what are the rights which are there, it's going to be an endless thing which is there. I do understand the constrictions and the time that I have. I think I have overshot by 10 minutes or so. But to make it a little more interactive so that I hear from you what your concerns are or what your questions are, and I'll be happy to answer that. Thank you, Rishikesh.
I'll request all the participants to keep on punching the questions we are noting down, and we'll try to club all of them and then try to put it before our esteemed speaker. Ma'am, it was really lots of wisdom coming with your tons of experience, and I'm very sure anyone from the legal fraternity looking at it, they can learn a trick or two from you. The first question I'll try to put before you is on the same lines of the last limb of whatever you have discussed. And this is something with the concept of clean hands as we discuss in any form of law. And this is applicable to the matrimonial laws as well. So basically, I'm trying to put before you is how important it is for both the parties or all the parties to come clean in their pleadings before the court, and how it impacts their case.
So this is the basic tenet of law. And not only that the parties have to be honest and transparent about what the things are, it is also the duty of the lawyer to direct them. Sometimes there are some lawyers, I would say with a lot of regret and a lot of sort of sadness in my mind, is who instigate people to write some things which are not right. That is why I said the role of a family lawyer, a person who does family law, has to be extremely constructive, has to be extremely positive. He or she has to be also a healer in some sense of the word, because people come to you in very troubled state of mind. You cannot ignite the fire. You have to douse the fire first. Only then you will have a very stable, a very rational, and to the best possible benefit and advantage to both of them.
Second question coming is the concept of multiple maintenance. As the law is, lady is well within her rights to initiate a proceeding for the divorce and claim for the interim maintenance, at the same time move proceeding for a domestic violence, and also under Hindu Maintenance Act. So how the law is in this subject matter?
Whose handiwork it is the handiwork of the lawyers, right? So I again come back to the same thing, that yes, there are several provisions which are there. So the lawyers may be right within their rights, but I'm sure there would be laws which would now come up, which would give some kind of an indication that you cannot have a double whammy or multiple whammies, as we call it in this. Because you are absolutely right. You can, let's take a Hindu couple. They can go under the Hindu Marriage Act for maintenance. Then this lady can go against under the Domestic Violence Act for maintenance. She can otherwise go under Section 125 CRPC for maintenance, Criminal Procedure Code, or Hindu Adoption and Maintenance Act also. So these are the 4 acts which are sort of available to the lady. So the idea behind the maintenance is to give her the support so that she's able to lead a life of dignity and grace. Is not to prosecute the husband and make him pay because of the whims and fancies of the woman.
Ma'am, one of the questions coming from Facebook Live, where it has been asked when there is a alimony in the form of a monthly maintenance,
right,
granted to a lady, and subsequently, let's say divorce has happened, she is entitled for a monthly maintenance as part of the settlement, and after 2 years she gets married, then what happens to this alimony?
So the monthly alimony, which is a monthly maintenance or alimony, which is granted by the court, is only till the period of her life or her remarriage. So during the lifetime she gets it, or on her remarriage that stops. Because then what happens is then you are no longer the ex-wife of the husband. Then you are the wife of one Mr. X with whom you are going to get remarried. So the monthly maintenance comes to an end. But on this point, so when we settle matters on behalf of the wife, and suppose if I'm a lawyer on behalf of the wife, I always prevail over the wife that it is better to get a lump sum, maybe 10, 20, 30% less than what your expectations are. But then that's your money and nobody can claim back that from you, even if you make more money or even if you get remarried. But the monthly comes to an end on the remarriage of the lady.
Next question coming: in a mutual divorce by a married couple, is the separation of 6 months is post filing the appeal? That is the I think he means the filing of the case. And how will the court take cognizance of such separation? What records to show to prove this? What is the maximum minimum timeline by which a couple opt for mutual divorce can get the decree from court when they do not have children? So basically this question is on the pretext of when a mutual divorce is filed by a couple, what is the time frame they have to show is the separation, or they can just sumoto go and say ki there is a they cannot live together and they wish to get divorced?
So I explained that when I was dealing with divorce by mutual consent. I think my friend was probably not there. It is in a divorce by mutual consent, the requirement is 1 year from the date of marriage, 1 year from the date of separation, and the divorce is granted after 6 months from the date of the filing. So the life of a mutual consent petition is one from the date of the filing for 18 months. If, for example, after 6 months, for some reason, the parties cannot go back to the court. So, for example, this COVID, courts are shut, and people and you cannot go, or any such things which are there, or certain give and take which has been agreed upon is not done, then the courts do adjourn the matter. But the life of that petition is maximum up to the 18 months from the date of the filing of the petition. But 6 months is the compulsory mandatory minimum period.
Ma'am, at the same time, when I'm taking all the questions relating to the divorce and the specific subject matter, I think it will be highly unjust if I don't take some tips from you for the young lawyers who are also watching this webinar. So what are some of the advice, ma'am, you would like to extend to the young lawyers who are looking at this webinar of today, and specifically from your background of handling the matrimonial laws, how they should be building their career?
So when I started this, I told you that there's a surge of these issues of matrimonial issues, disputes which are there. When I started my practice roughly around 18, 20 years back, I mean, there were very few cases which were handled and. But today I see the courts are flooded and literally flooded with number of the clients who come. So we have 7 floors, a 7-story building here at the Bandra Kurla complex, the family court, and there are 7 courtrooms. And every court has around 70 to 80 cases every day. So please multiply that into 7. So that is the volume which is there. So yes, there is a surge in the cases. Yes, there are a lot of matrimonial issues which are there. So in fact, we have so many lawyers who are otherwise doing corporate law and now switched over from the corporate law and come down to matrimonial law because this is the field that they find interesting or something which is of their choice. The advice that I would like to give the lawyers here is that please, you have to be absolutely honest to the court. And firstly, you have to be honest to the client. Do not take the client down the garden path. Be very honest, and someone with experience should be honest enough and candid enough to tell that this is what you are likely to get and this is what you are not going to get. So what is the option that you have? Because a client comes to you with a lot of trust and faith, and he reposes that trust and faith in you. It is your duty as a lawyer, as an officer of the court, to give him or her the right guidance. That is point number 1. Point number 2, if you want to do family law, please do not ignite litigation. Please do not fuel the fire more if there is an issue between them. You may gain a little bit of an advantage in the initial stages by just catering to the revenge or the anger or of the clients which are coming to you, which is there. But in the long run, it is not good for the family which is got into that battle in the courts to deal with it. Thirdly, more importantly, is that honesty to the court is absolutely necessary. I'll give you an example. If I'm a lawyer and I have to conduct a cross-examination, I'm not prepared, correct? For whatever reason, I've not studied, or I'm traveling, I was doing anything. Most of the lawyers would send one of the juniors or the colleagues and say that she's unwell, she's not traveling, she's got personal difficulty and she cannot. Is this being honest to the court? But what I do, and which I would advise all my junior lawyer friends to do, is go to the court and be honest to the court and say that yes, it was my time to cross-examine. I'm not prepared. Could you give me a week's time? The courts will be more than willing. But if you play tricks with the courts are going to come down very heavily. Your reputation is most important in any profession, all the more in the legal profession, because people should believe that this is coming from you. This should be the truth. That kind of thing which is there. And obviously, there's no substitute to hard work. There's no substitute to doing research and understanding the law, because law is ever evolving, and the judgments of the Supreme Court and the High Court are something like students of law like me also learn every time I read a judgment.
Real words of wisdom coming. I think all the youngsters should hear again each word what ma'am has repeated and try to gain out of it. The next question coming our way. In the cross-border litigation, which courts would be upheld, UK or India, in regards of child custody?
So that's what I said. So the UK court, in the case which I gave you, had given an order for the ward to come back. But the courts in India have consistently held that yes, we respect the orders of the other court which is there. There is committee of courts which is there. That is mutual respect for this thing. But the guiding principle will be the best interest and sort of welfare of the child. So the courts will assume jurisdiction in India because they feel that they have to look after the welfare of the child. So in a way, both the courts had jurisdiction. But since the child was brought here, the courts in India would decide who should be granted the custody of the child.
How to expedite a maintenance case move faster in Mumbai, where husband says there is loss in business as they have no money?
I've not understood the question.
I think basically
you expedite the maintenance case.
Yeah, basically that they are trying to say.
Okay. So expediting the maintenance case is the need for every woman or the applicant who is there before the court. But what happens is that when that is where I'm saying that you say that I want $100 as my alimony, then you have to prove to the court that why do you need 100 rupees? Sorry, 100 rupees. Why do you need 100 rupees for your alimony? Then the other person will come and say, why does she need it? She's got this, she's got that. There is pleadings, there is counter pleadings. Then the husband has not come out clean, so I make an application to the court as a wife's lawyer and say, listen, he's giving wrong figures in his reply. Ask him to produce all his income documents. If he's working, then his CTC, then his income tax returns, Form 16, etc. to be given. Or if they are into business, whatever the profit and loss and balance sheet, etc. to be given. Because ultimately, how is the court going to decide? I say he earns 100 rupees. He says, no, I earn only 25 rupees. Now, the courts cannot decide what it is. So then the documents come into place. But to expedite this, please understand the reason why there is a delay, and I'm sure, and I will admit to the fact that there's considerable delay in some of the cases for deciding maintenance, is only because of the sheer volume and the sheer adjournments that are happening in the courts for various reasons. So everybody wants the cases to be expedited, but ultimately we have to live within the system, and some of the we have these difficulties in courts.
So just to take it forward to just what we have stated, that's why the couples must act in such a manner that before doing anything, they should think twice, what is the time frame, what their lawyer is advising, and so on. Apply your own common sense also. And definitely, as they say, if you go to the cream or the more experienced lawyer, definitely there will be difference compared to the other, as in any field. Now, the next question, it's something I think not more than more of a criminal law jurisprudence question. whether 498 case can be withdrawn by the wife. So basically the querist is asking once a 498 has been filed, FIR has been launched, whether she can withdraw it, or only the next mode is to get it quashed from the High Court.
It is to be quashed under 482 of the Criminal Procedure Code. So this quashing could happen simpliciter because she wants to sort of get done with the case, or sometimes the parties after the filing of the 498A arrive at certain consent terms and they say, okay, now we want to part amicably besides all these cases which were there. And one of the conditions will be that the wife will, so the quashing is done by the husband and the wife has to cooperate and say that I was a complainant and I have no objection if the Honorable Court quashes these proceedings which are.
One of the querists is asking one drawback though, that living cost increases per year. Inflation is also increasing, but monthly maintenance doesn't increase. So does the Domestic Violence Act or other maintenance is justified as a second avenue can be availed? So basically what they are trying to ask is if they have opted for one and in that X amount has been granted and subsequently there is an inflation, so should they opt for a second remedy?
So the remedy in such cases is that you can go back to the same court. For example, the court has granted you maintenance, but the inflation has gone up, the cost of living has gone up, and situation is the same. You can go back to the same court and ask for the enhancement of that amount. So you don't have to go for an alternate other remedies which are there. It doesn't mean that you have to go under the domestic court. You go back to the same court and say you've granted me 100 rupees, but this is what the change of circumstances is, and kindly enhance this amount. Maybe the kids have grown up. Maybe they have their coaching classes are there. These are very practical problems that mothers in most of the cases face. That okay, it's some amount is given, but the coaching classes should take 1 lakh rupees or 2 lakh rupees, and it's not possible for her to manage the kids' things. Then the courts are very sensitive to these things. I'm just giving an example of the kids. Even for her own personal expenses, if there's a change of circumstance, then you can seek enhancement from the same courts.
Does burden of proving the cruelties on the hands of person asking for a divorce?
Of course, 100%. 100%. That is why I've said that in fall divorce, it's very difficult for a court to decide because they don't know what happens within the four walls of the house. It's your word against my word. And that is why it's absolutely necessary for the petitioner to prove his case in a court of
law. Next question coming is, it has been 4 years that I've got separated from my husband and I have a 9-year-old son who is still with his father. It has been 10 years of marriage filled with physical and mental incompatibility. I have served him thrice now, while no response comes to him from mutual consent. He demands a property that my mother owns as negotiation for divorce. I am independent and is independent, and we both on what I am to do. I do not want to use any harsh words. The child is involved. So basically this lady wants to know how she can get a divorce in such circumstances.
So number one, I would not like to give any advices because opinions. I'm basically dealing with a broader subject, which is
right.
So she can go to a good lawyer who will advise her properly. I do understand what her concerns are,
right.
But webinar is for everybody, and these are the broad tenets of law. The provisions.
Right.
I hope you understand.
Yes. So the next question coming is whether once the one-time alimony has been settled, can wife claim even further after the settlement?
Again, yes, same thing. Change of circumstances. If for example, let us say a lump sum alimony has been given. She's not got remarried. God forbid she gets something like cancer or something for which she needs money for her treatment. Okay.
Right.
And under such circumstances, she can go back to the court that yes, you had granted me a lump sum of say 1 lakh rupees, and we give an example. But these are the expenses that I have. Today I'm battling with this disease and I have no money, I have no support system. The courts will consider. See, that is what I'm saying. Issues of child custody, issues of maintenance, alimony, though they are there, they are ever growing and ever evolving, and you can always go back to the courts only if you have a genuine ground to do so, and the courts will consider if they are satisfied.
Next question is a very interesting one. I don't know how to put it. Is the divorce also applicable to gay marriages permissible in India?
I wish we had gay marriages right off. As of now, with great difficulty, the the community has been able to get 377 struck down from the Indian Penal Code, which was one of the most barbaric laws that existed.
Right.
Okay, so there is, I mean, unless there is a gay marriage, only then there will be a divorce in the marriages. No? So as of now, there is no such enactment or law which talks about gay marriages. They have just today recognized the LGBTQ as the people who are also in the mainstream like you and me, and
Right.
they are also the same. So I think it will take some time, but I think the foundation has been laid.
I think we are almost at the end of our session. Uh, just one more question. Ma'am, what is one advice you will give to couples who are planning to get married?
So I'm going to take a minute more
Sure.
and share a real life thing. I was sitting in my chambers, and an appointment came. A young couple came. They were in their late 20s or early 30s, and they said, and they asked me. So I, like when they come, you ask, yeah, what happened? When did you get married? And what is the problem? And what do you want? I said, no, 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 we're not married. We want to ask. I said, yeah, what is it? They said, what are the causes for marriage? Breaking? What are the warning bells? What would you advise us? And so I said, why are you asking all these questions? On which they said that we are in love, we want to be together forever. That's what at least our hope is. And we wanted to come to you and understand from you, who deals with these turbulent relationships in your profession as a lawyer, then what are the do's and the don'ts that you would say? And what are the warning bells that you would want us to be aware of that such a thing that happens? And I thought it was a very, very, very pragmatic and a very positive way of understanding. Because normally people go to counselors or couple counselors earlier to find out how things are. But they came to a divorce lawyer, if I may use that word, to understand what the situation is. So the only advice that I can give is that there are various cases which are there. Now you will have to understand one thing, that why were marriages which were say in the 80s or 70s, our your parents, our parents, our grandfathers, is continuing, and why is there so much that today? So there are a lot of factors which are there. So there's lack of tolerance. There is a lot of sort of my way or the highway, or there are extreme cases also where there's hurt, there's pain, there is violence. There are various factors which leads to the whole thing. But for marriage to be successful, I think it is an investment that you have to do, and you have to wait for the returns. And those returns are not short-term day trading. No, they are the long-term returns that you get. And the long-term returns are the children and the happy family. And the children, when they grow up and they have their children, to be sitting there and watching them grow. I think those are the biggest returns that you can get in any marriage.
Real words of wisdom comes not only in terms of the legal cases what you have handled, but also in terms of the age. As my mother always says to me, I have seen more Diwali than you. So definitely you have seen more Diwalis and Holis than us. So that experience is speaking. Just in the parting, I would like to address to all, just because if we have an accident, that doesn't mean we stop driving. Just because of one bad experience or two, that doesn't mean ki we stop believing in the institute of marriage. uh, as the webinar was coined, two sides of a coin. Similarly, there will be issues from both the sides, yet it is not a gender problem as such. It has to be balanced. No law is bad or no law is good. It is as good as the parties involved and the professionals involved. Ma'am, I am humbled and I have no words to express my gratitude to you for agreeing to come and address this webinar. And not only to address it, but with your whole heart and with all your contributions, what you have given. I am thankful on behalf of Udan Saluters.
Thank you so much for inviting me, and thank you for making me a part of this great interactive evening. Thank you so much.
Thank you very much. With that, friends, I would like to end today's webinar. Just one brief information. Tomorrow, again, we are having one more webinar. It is on the nutrition, health, and the diet. Meenal from team Rutuja Devarekar will be coming. Thank you very much. And once again, thank you very much, ma'am.